Current Affairs.
This is Akashvani. In the weekly program Current Affairs, now we bring you a discussion on key bills in Parliament this week. The participants are Praful Ketkar, political analyst, and Shubhamoy Bhattacharjee, economic analyst. Moderator is Vaibhav J. Srivastav.
Welcome to today's episode of Current Affairs. In today's episode, we will be discussing about the major bills and their significance which were introduced in the Parliament. To have an insightful discussion, we have two very special guests with us in this program. We're joined in by Shri Praful Ketkar, Senior Political Analyst, and Shri Shubhamoy Bhattacharjee, Economic and Political Analyst. Welcome to the show.
Thank you. Namaste.
First, we will take up the bill, the Prevention of Insults to National Honour Amendment Bill 2026. What is the bill? How significant is it? What was the need for the central government to bring in this in today's scenario?
We know that Vande Mataram was an iconic national song that inspired our freedom struggle. And government has, recognized and, notified the full version of Vande Mataram. So on 24th July 2026, in Rajya Sabha, the bill was introduced. Rajya Sabha subsequently passed it on 29th and Lok Sabha passed it on 30th. So this basically now an act which amended the earlier version, Prevention of Insults to National Honour Act 1971. Now, according to this act, this prohibits intentional prevention of the singing of national anthem and causing disturbance to any assembly engaged in such singing. The bill extends these provisions now to national song also, that is Vande Mataram. So these now offences are punishable with imprisonment up to 3 years and a fine or both. And in subsequent conviction, the punishment will be of minimum of 1 year. So basically, this inculcating values and the fundamental duties that we are expected to follow as citizens of India, honoring our national symbols, including the national flag, national anthem, national honor. So this bill basically meant to prevent any kind of insult to all these national honors. And that is why this bill is very important.
My next question would be to Bhattacharjee, sir. My question is regarding two very important bills. First one is the Taxation and Other Laws Amendment Bill 2026, and the other is Foreign Contribution Regulation Amendment Bill 2026. What is the Taxation Bill? How important or significant it is for India's revenue generation and its sustainability?
The set of bills that was cleared by Lok Sabha yesterday, these are all money bills, so essentially it is Lok Sabha which has got the right to decide on them as per the arrangement mandated by the Indian Constitution. So these bills carry forward the policy that the India government has been trying to make it very evident on several aspects. But the most important thing is, first of all, to make transactions with India by foreign entities much more smoother than it has been so far. A very major thing that has been done is that, as you know, in last year, the government passed the new Income Tax Act 2025. And that has been a seminal change in the Indian income tax laws because it replaces the Income Tax Act of 1961. Now, having done that, there are obviously, since an Income Tax Act is very wide, there are lots of corresponding provisions in other acts also, which over time that comes in. They are from the 1961 Act. So those acts also needed to be changed. One of those was the Payments and Settlements Act 2007. So what has been done this time by the Finance Minister, Ms. Nirmala Sitharaman, is that she has brought in all those changes into one to be consolidated under the new Income Tax Act. And that's very important. So these are not procedural. What it does is that they make all the other acts become forward-looking and relevant to India's business in a way that helps India considerably. To give an example, India government is now a very prized member of the global bonds. There are lots of bonds, the Bloomberg bond, the FTSE bond, there are other bonds which are indexes where India is a sought-after member. Now, in those bonds, when investors from abroad invest, then naturally they want a tax treatment which is somewhat similar to what is the global structure. Now, India already has that structure, but it wasn't being reconciled with many other regulations. So India has therefore as part of the changes that the finance minister brought in, the structure on withholding tax, the structure on reporting of tax entities, the structure on reporting issues which are inadvertent. There are lots of data and others which are put in by taxpayers, companies, when there are issues about what reconciling different data. All of these earlier had penal provisions or issues which were uncomfortable. Those have all been streamlined out. This year, just after the budget session, Finance Minister introduced an ordinance making clear what is the government's intention. And that has been very widely understood and that has been widely appreciated. As a result, you would find that one of the things that has happened is that the rate of foreign investment in India, which had declined because of the disturbances globally, they were not created by India, but they had declined, has started to pick up. July has been the first month after several months when India has recorded a positive net inflow of foreign investment. Now, all of these are not coincidental or random. They have happened because of these changes that have been brought in. So they together have made very substantial impact on the tax provisions. One provision out here, which I think is very important to talk about, is one on the payment system, on the UPI, the merchant discount rate. Now, the thing to make it very clear is that what the government has done is the government has said if a company comes in with a UPI product, through that we can make payments to any merchant or anyone, any friend. Supposing if I'm making a payment to you or you're making a payment to me. So any of those payments, there was a restriction on whether the company which was doing the transaction on their behalf, what is called the carrier, could not charge any fees. The government has done away with that provision. So the government is saying that under the tax laws, the companies can make the check, can make the payment or raise the fees. Will they raise the fees? Will they impose the fees? That is a commercial decision of a company. Right. The company need not necessarily do so. The company might feel, no, I'm comfortable running my business without charging the fees. So it is not that the change in the tax law makes the fees inevitable. It provides an enabling provision for the companies to charge if they feel like it, if they need to. So it's a commercial decision. And naturally, a commercial decision will be taken by the companies when they need to.
That was a very insightful observation on not just the Taxation and Other Laws Amendment Bill 2026, but also on the bill to amend the Payment and Settlement Systems Act 2007. I will go to Prafulji. Prafulji, what is the significance of the Foreign Contribution Regulation Amendment Bill 2026? What is the social impact? What is the bill all about? How will it make changes, or how will the revenue streams coming from outside in India or from the international communities either be altered or not? Is it a myth? What is the bill all about?
Foreign Currency Regulation Act is not a new thing. Since 1976, we have the Act, and across the world, each and every country tries to, somewhere supervise and monitor foreign money coming in their country for various welfare activities through various organizations.
Absolutely.
Now, what happens many times, this foreign contribution, the regulatory framework is manipulated through various means. So what government has decided now, as we have seen since 2016 onwards, there have been various amendments of 2020, then 2024 to make this monitoring more effective. Now, as a next stage, what government is trying to do, where the foreign currency regulation FCRA licenses are not renewed, then that, because what many NGOs, foreign funded NGOs do, that they are either not submitting their audited statements on time, or they are not complying with other kinds of the mandatory compliances that they are supposed to submit to the Home Ministry. So in that case, this proposed bill is going to do 2-3 important things. One, it is giving the authority to the government to take over the assets created out of foreign funding. But in this case, there is one important provision that places of worship, if the asset is in the form of places of worship, then the religious character of that place will be maintained. So that is one. Two, government can what is called as the cessation of certificate. So if FCRA certificate is not renewed or is surrendered, or for some reason government has denied the renewal, then that certificate will be seized, means after that particular date, that organization will not be eligible to receive any foreign fund. And in that case, the designated authority, the new position will be created by the government of India, the appointed authority which will supervise, manage, and dispose of foreign contributions and assets derived from them, that is, the organizations whose registrations are seized. So these are the three important components. So basically, this is related to bringing in more accountability and transparency related regulatory framework when it comes to the foreign contributions to various welfare activities, social activities in the name of NGOs, in the name of civil society that many organizations are getting. Earlier, we remember, 56,000 organizations used to get this kind of foreign funding because many organizations refused to submit their audited statement. Earlier, government brought down the administrative expenses part of foreign contributions. That means if you are receiving, say, 100 rupees in the form of foreign contribution, you should not spend more than 20 rupees on the office and administrative expenses. If you are getting it for education, you should spend it on education. If you are getting it for healthcare, you should spend it on healthcare. If it is for rural development, well, it should be for that purpose. So effective utilization, bringing in more accountability and transparency is the basic purpose. But for that, now the designating authority will be created, and even the assets illegally created, because now after FCRA license is seized, that organizations do not have authority to manage FCRA related funding, so that particular property or asset can be seized. That is one of the most significant provisions that bill is expected to bring in.
Absolutely. Shubham, sir, your views on the same, the Foreign Contribution Regulation Amendment Bill 2026 and every other aspect of the bill.
FCRA was essentially started to be amended during the UPA government. That was the time when the FCRA changes were first introduced.
Gee.
Later on, this government has decided to change, and as Professor was pointing out, to create provisions to make the FCRA more, first of all, clean, in terms of clear what is it that it's actually trying to do, and secondly, making the control of the government very clear as to how it will be exercised. Now, first of all, one thing that is very clear is that whom does it apply to? It applies, as you said, to trusts, organizations, and all sorts of things. However, the challenge is that many organizations maintain that sort of a structure also for tax purposes. For tax purposes, they have had benefits which comes by retaining that sort of a structure. If an institution, for instance, changes itself to a Section 8 company under the Companies Act of 2013 and as revised in 2016 and so on, then the FCRA problem or FCRA challenge doesn't exist, because then the company can get foreign contributions in the form as any other company does, by means that are available to any company. So then the FCRA issue isn't there. So FCRA essentially is for those institutions which decide not to travel into the Section 8 non-profit company status. Remember that as a non-profit company, the taxation rates would be lower, but still they choose to exercise it. So who would be the FCRA? Who would be the institution that would want to retain this? There will be institutions which are connected with education, with social affairs and other things, which is fine. But lots of times what happens is the route to access foreign funds have often been used by entities which are not necessarily in the field of social welfare or social welfare as it is understood well. There have been lots of cases where funding has come into India from sources for institutions for purpose which was supposed to be for the society, but has ended up building up assets of individuals, houses, farmhouses. There have been lots of those cases which have been documented, which are not really the reason why the FCRA funding should have come. So the FCRA this time is, as Professor rightly pointed out, has given the government the power to seize many of these assets if the government has sufficient reason to do so. That's one of the first things. And I think that is the most challenging aspect of this bill, or the most controversial aspect of the bill. The other part is that about the renewal of registration. Now, just as there have been issues pointed out that lots of trusts have had their FCRA license cancelled, it is also not often realized that much larger number of organizations have had their registrations renewed and are continuing the work.
Absolutely.
And are continuing the work in the way that they need to. So it is not as if that the moment an FCRA registration gets cancelled, that's the end of the road for the institution. Absolutely not. There are institutions which are, and there are thousands and thousands, but as I said, there are far more than the number of institutions whose registration has been cancelled, and they are continuing the job because they are doing the job efficiently, effectively, for the purpose that they want to, for the specific directions that are needed. So, for instance, issues like skilling, issues like education, issues like environmental support, issues like supporting lots of renewal of historical properties and other things, those are continuing. Those have not been a problem. The problem again comes in when the aims of the organization is not very clear as to what is it supposed to be about, what is it trying to do. And there, again, it's an issue that is therefore needs to be looked at. In this context, I would want to point out that India has been a very interesting place where lots of foreign countries have often been very happy to contribute. In fact, under Mr. Atal Bihari Vajpayee, the then Prime Minister, the government had brought in a very interesting law in the year 2001, where it says that India government will not accept foreign charities excepting from 5-6 organizations, including the World Bank and the IMF. It created such a furor. It created such a furor because many organizations from across the world thought that India was a place to show their angst, to show the sense that India needs support. It's a poor country. It doesn't have the capacity to develop itself, help itself. So even small sums of charity used to come through the India government. It would come to India was often that India was a very good record keeper. India would keep absolutely a perfect account of all the money that came in. So this was a very, very interesting situation. And when it was withdrawn, when that provision was brought in, lots of countries protested that we are not being able to give charity. And India said, we don't want. The then finance minister said that India is a country but that can take care of itself. It is now contributing to the IMF and others rather than taking loans from the IMF. So it's best that these charities go to countries and areas where the charity is needed.
Absolutely.
So charity is actually a very interesting thing. And often these foreign contributions serve the interests of those who are giving rather than the interests of those who are being sought to be served.
Very
so that's
well
something
said.
that needs to be understood very well.
Very well said, sir. So basically the points remain the same, that it is a matter completely internal to India, and whichever money is coming in should be used for the stated purpose only and not for any other purpose. A very important bill that we would be discussing now with Prafulji is the Micro, Small and Medium Enterprises Development Amendment Bill 2026. The bill has been cleared in both the houses of the Parliament. Your views on the same?
So I'll just make one more comment about FCRA. One,
G.
India has the highest number of NGOs, 3.7 million roughly registered. And secondly, if we compare that to China and the US, China has a centralized authority under Ministry of Internal Security, and again it is supervised by their foreign ministry, every penny coming through the foreign funding.
G.
Similarly, there is a FARA law in the US, and again it is a very stringent centralized law, so every penny coming in the name of social welfare is scrutinized. So because it is now linked to the international affairs, that is why I'm just making this small comparison.
Please.
Now coming to the MSME development bill. Again, it is a very, very important. This bill has basically classified enterprises as MSMEs based on the investment in plant and machinery in case of manufacturing and equipments in case of services. So the classification of MSME itself has changed with this, because now investment coming in the form of plant or machinery or in case of equipments. So this removes the earlier thresholds and modifies the criteria. And now it is not limited to just turnover, even the investment made. So under this act, now a person intending to establish MSME can be engaged in manufacturing. So it is basically a promotion of the manufacturing sector. The bill also adds that every central public sector enterprises must settle all invoices for procurement of goods or services from MSME through trade receivables discounting system. So again, this is RBI regulated electronic platform. So MSMEs can now raise funds from financiers against invoices due from buyers. So it brings in more liquidity. It encourages manufacturing sector, and it also sets the timeline for mediation if there is any issues related to the service provider and refer to the related to payment disputes. Then in 90 days that this has to be fixed. So all these three important things. One is related to criteria of registration, second is related to settlement, and third is related to the mediation. This basically, give very, very enabling provision related to the new classification of MSMEs.
Absolutely. Shubhamoy sir, your views on the same? How important is this bill and how important overall is the micro, small and medium enterprises when the government talks about inclusivity, when the government talks about the sustenance of employability? How important is the sector and this related bill?
This bill that has been passed by the Parliament, it replaces the Micro, Small and Medium Enterprises Development Act of 2006. Now, what does that do? It essentially says, so it's a 20-year act that has been changed. And the big changes that comes in, the full and so made points, is that essentially it makes the operating conditions for MSMEs easier. How? First thing, one of the biggest challenge of the micro enterprises and even the small and medium enterprises is the fact that they raise bills, they sell goods, they raise bills, but often those bills are not cleared in time. The bill now says that every central public enterprise, whenever it buys anything from the MSMEs, that bill has to be put up on what is called a factoring market, which is a trade receivables discounting system. What does that mean? That the moment the bill is raised by a company and has been accepted as a bill by the public sector enterprise, the bill, way before it's been paid or cleared, the bill can now be used by the micro enterprise, small enterprise, on a market to be sold. So for instance, a company has raised a bill of, say, 5,000 rupees. That small enterprise does not need to wait for 60 days to get the money from the central public sector enterprise. Instead, it can simply go on to this market and sell the bill. So there's somebody else who's buying the bill and will sell the bill at discount. So instead of, say, getting 5,000 immediately, it might get 4,500 or it might get 4,400. But the point is, it has got cash immediately. Now that reduces their working capital pressure tremendous. That's a discounting facility that allows them to create it so that market becomes robust. And those who buy the bill, they will then have the capacity, because this will be the financial institutions. And the financial institutions will then push the enterprises to clear the bill, because the bill has been recognized as a bill. So the small enterprises are freed of the pressure of having to wait for when their money will be coming. That's a very big change. The second thing is that the definition itself of the small enterprises has been made much more flexible. The Act had classified MSMEs based on investment and equipment in the case of services. So if a MSME was manufacturing something, then the size of the manufacturing, the plant and machinery was the operational thing, and it was equipment in the case of services. Bills just removes this threshold. It gives the central government the right to classify enterprises MSMEs based on investment in plant or equipment and turnover. So that makes it much more easy for a company to be actually classified as a small enterprise and get, for instance, the benefit of the factoring market. So these sort of things becomes, and since this is the filing of memorandum by the companies, by these small enterprises, has been made voluntary for the MSMEs, and it has been made digital. The way the MSMEs can work has been made, as I said, much more flexible, and gives them the capacity to concentrate on their business rather than have to look out for the paperwork. It literally clears a lot of paper obstacles for these enterprises to run themselves efficiently. So to that extent, it's a remarkable change. It was very necessary, and it's good that it has come, and it should be of immense help to about our 64 million micro and small enterprises.
Absolutely. Yeah. Two more important bills. The first one, and I would go to Prafulji for this, the readjustment of representation of scheduled tribes in assembly constituencies of the State of Goa Act 2025. How significant it is, your views on the same?
In various states, it is a very interesting scenario where ST communities have a different kind of combination and different kind of representation. Now this act, which came into effect, was passed yesterday. It is basically promotes a political reservation for scheduled tribe communities in the 40-member Goa Legislative Assembly. Now it has specifically mentioned the names of the tribes, that is the Kunbi, Gauda and Veli tribes. It is a significant shift because in the previous structure, Goa didn't have any reservation or representation for the scheduled tribes. Now, Election Commission will use the updated census data to designate specific constituencies for this reservation purpose. But basically, this means scheduled tribes of Goa now will have representation in the assembly. They will be categorized as scheduled tribes even in the census, and their political participation and representation will be ensured.
So a positive and a big step towards the representation of the scheduled tribes. Quick views from Shubhamoy ji on the Bankers Books Evidence Bill 2026. What is the bill? How significant it is?
This is again something. These bills look procedural. But what they do is that they make a life for the financial sector much, much more easy than in every time they're cleaned out. So this is the bill which replaces a 125-year-old act. You can imagine how the world has changed. It actually gives what are the sort of evidence that can be used in a court of law by a bank is actually getting updated. So digital records, standardized certificates, authentication by digital signature. None of this was technically something which is admissible in a court of law by a bank. And you can imagine what that meant, that every piece of those records had to be then translated into paper, notarized by the court-appointed commissioner, created and then filed separately, each court, each time, each paper separate. It is a paper nightmare and actually clogs up the banking efficiency enormously. We are talking about Insolvency and Bankruptcy Act. We are talking about the fact that there should be faster mergers and amalgamations, quick turnaround of NPAs. All of that comes up against a hurdle that papers were the most important thing, or rather the only thing that courts could accept and would accept as evidence from banks. So this act changes all of that. What is an evidence from bankers' books? It doesn't need someone to literally carry a book into a court to show, hey, here's the record and this is it. First of all, those books don't even exist. So you can imagine with the amount of chaos that used to create for any bank to establish its credentials, establish the evidence, establish anything. So all of those have been made clean, and that intuitively, it is so obvious that this should have been done much way earlier. As great that's happened now.
Absolutely, yes. Better late than none. And thank you so much for your insightful views to both our special guests, Praful Ketkar ji and Shubhamoy Bhattacharya ji, for discussing the bills and acts of the Monsoon Session 2026. Thank you for joining us in this episode of Current Affairs.
Thank you.
You were listening to a discussion on key bills in Parliament this week. The participants were Praful Ketkar, political analyst, and Shubhamoy Bhattacharya, economic analyst. Moderator was Vaibhav J. Srivastav. This program was produced and presented by the News Services Division of Akashvani. You can listen to it on our mobile app News on AIR. This program is also available on our YouTube channel News on AIR Official. You may share your feedback about this program through email at airnsttalks@gmail.com or WhatsApp on 9289094044.
Current Affairs.